Alive.
Thank you. We're back in Senate Judiciary, switching gears to S-45, the right to farm bill. We have Wedge Council with us to do a little bit of a walkthrough, and there was one proposed change that I brought up regarding mediation and just clarifying some of the language around there. But yeah, Mike, just so you're aware, we are going to have to vote for S-44, so we'll have to break for a few minutes. 20 minutes, just so heads up, but
sure.
Of course.
Do you want me to do a walkthrough or?
You could do just a 5-minute refresher for
Sure.
everybody since we're gone, and then we can talk about mediation.
So you're on page 2. This is Mike O'Grady with Wedge Council. You're on page 2, line 8. You're in the chapter of law that exists now, which provides nuisance, some protection, to farmers from nuisances. And you'll see in the legislative purpose section, which is not being changed by this bill, going on page 2 to page 3. In order for the agriculture industry to survive in the state, farms would like to change, adopt new technologies, and diversify into new products. And then it is the purpose of this chapter to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits. You discussed with me when I first walked through the bill with you how this law compares to comparable laws in other states, and all states have a right to farm. It is relatively less protective of farming than other states, and consequently what is being proposed on page 4, line 14, is to strike the current system by which there is a rebuttable presumption that a farmer is not creating a nuisance if certain conditions are met. And those conditions currently are: the farm has to be conducted in conformity with federal, state, and local law. It has to be consistent with good agricultural practices. It has to have been established prior to surrounding non-ag activities. And it is not significantly changed since the commencement of the prior surrounding activity. But that presumption may be rebutted by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference. So it effectively places a burden on a farmer to show that they are meeting all of those criteria in order to receive that nuisance protection. And even if they do meet all those criteria, a plaintiff can still overcome that presumption and still sue them if they show that there's an activity that has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with usage, enjoyment of the neighboring property. So what S-45 does is it moves more towards a model from other states, specifically Kentucky and Michigan, where no agricultural activity, on page 5, line 8 through 10, no ag activity shall be or become a nuisance or trespass when the activity is conducted in accordance with generally accepted agricultural practices. And generally accepted agricultural practices are defined, and they're defined on page 4, lines 6 through 13. They are the required agricultural practices for water quality, which all farms have to comply with. They are the requirements of the Agency of Agricultural's use of pesticides rule, which farmers have to comply with if they're using pesticides. And then it's practices conducted in a manner consistent with proper and accepted customs and standards, followed by similar operators of agricultural activities in the state. I will say that there is no standard for that right now, that would have to be litigated about what those practices are. But look at the bottom of page 4. That's already effectively part of the criteria for the existing rule. It has to be consistent with good agricultural practices. You're basically saying that instead of it being good agricultural practices, it has to be practices conducted in a manner consistent with proper and accepted customs and standard, followed by similar operators of ag activities in the state. So you will have testimony in court proceedings that says, oh, this is a proper and accepted custom. This is what the operator here does. This is what the operator there does. You will have experts from UVM Extension, from the agency will say that this is what is recommended. that will be part of these claims going forward until there's precedent set about what those practices are that provide this criteria. And I just to, as an aside, this bill isn't going to prevent litigation. It's going to provide farmers more protection in litigation. And it may prohibit some suits from going forward, but it won't prohibit suits from being filed. So just to be aware of that. You heard testimony from a farmer who was subject to a suit. This law probably would have prevented that suit, but it would have provided them more protection during that suit. One significant proposal in S45 is on page 5, line 12 through 16. It's clearly providing that the plaintiff alleging that the ag activity is a nuisance or trespass is the one that has the burden of proving by preponderance of evidence that the ag activity is not conducted in accordance with the generally accepted agricultural practices. So instead of the farmer having to show that they meet all of those criteria in order to get the presumption, the plaintiff have to show that the farmer's activities that are allegedly the basis of nuisance or trespass are not conducted in accordance with generally accepted ag practice.
Senator Bowles.
Thank you. Thank you, Michael. In other civil cases, is the burden of proof on the plaintiff?
Yes.
Okay, so this is sort of alignment.
This is consistent with general tort law. Then when you bring a claim, the burden is on the plaintiff to show that a person was negligent, that a person assaulted them, etc. It's on the plaintiff generally to bring to show the burden of evidence has been met.
Are there any other exceptions in the law aside from farming currently, where the burden of proof is not on the plaintiff?
There are times when the burden shifts. One example is in public records law. If a public agency denies access and there's appeal, there's a shift to the agency to prove why that they are withholding that document, that document was accepted. So there are times when the legislature shifts that burden.
Okay. Okay, thanks.
I do have one quick question, Mike. On page 1, could you just clarify on line 13? Give me the difference between what's consistent with nuisance or trespass. 2 different examples of that, or are they different?
They are different. So nuisance is when an activity on a property negatively affects the use and enjoyment of the property by a neighbor. And nuisance can be private. It can just affect discrete groups of people, or it can be public. It can affect a larger body of people. Here, most of the time, it's going to be discrete. It's going to be private nuisances. It's going to be odor, aroma. In some situations, it could be runoff. It could be water. It could be animals. So that's the type of, it could be noise. That's the type of nuisance from farming that could affect the use and enjoyment of the neighbor's property. Trespass, it could be runoff, and runoff has cross boundaries. Trespass is when something you or something within your possession crosses the boundary onto the property from your land to another's land without permission from the receiving property owner.
Like cattle getting loose.
Cattle getting loose, or sometimes with ag, there's been allegations that pesticide application has resulted in a trespass because it's drifted onto neighboring land. You saw a trespass claim in the testimony you heard from the farmer prior to town meeting week. Because that was about increased water flow due to subsurface tile drainage crossing from that farmer's property onto the property of another and causing that was in that action. Part of the action was trespass. And so those are the types of activities that could be, be the basis of a cause of action and could receive protection under this bill. And it's fairly consistent with other states. Not every state has protection for trespass. Some are just protection for nuisance, but many states do have protection for trespass. Thanks.
2 questions. Just to sort of further clarify for myself, trespass sort of crosses into a physical incursion onto someone else's property.
Generally, yes, you need that physical incursion. There are cases where the incursion is kind of microscopic. There's a case from Pennsylvania about a brewery and how everybody was complaining about the odor, but somebody showed that there was something like physical in the emissions and that. But it's a trespass against that brewery.
Okay. And then my other question is, do you know how many states include trespass in their right to farm laws and not?
I can't say off the top of my head, but I can figure that out.
That would be really helpful. I have concern about trespass being included. I think for me, there's a difference between hearing animals or smelling animals and something physically crossing into someone else's space.
Yeah, and I think that one of the questions which ends up delving into, I think, agriculture, the ag jurisdiction is, what are the rules surrounding the trespass in terms of, let me rephrase this so it makes more sense. For example, generally accepted practices of how you keep your cattle in a certain area. If the cow accidentally makes it through a gate and onto somebody else's property, even though somebody was, taking all the correct steps, I think that's the situation in which, the farmer can be protected. But if the farmer is doing something outrageous and not following all the rules and just saying, hey, you know what? I think my cows can go on your property. I think that would obviously not be something that's consistent with proper accepted customs and whatever the rules may be in the agency of agriculture. So that's something that I was kind of grappling with the week before last in terms of how much do we get into the weeds of agriculture jurisdiction. I do think it's definitely worthwhile to, when we hopefully send this to the next committee, kind of giving them the task of reviewing, what the standards are, so that situations of obvious, egregious trespass has the ability to be properly addressed. But yeah, those are my thoughts on that.
I do think, for example, using trespass and animals escaping, there are generally accepted standards for maintaining a free strand fence, for monitoring, for having exclusionary devices on rivers and waters, etc. So if someone wasn't maintaining their fence in a way, I think that could be demonstrated by a plaintiff to say that it wasn't being maintained according to good agricultural practices that are the norm in that area. I don't think I think it will be fact specific. I think it will be testimony specific. It is not going to be easily understood right now because it's going to be fact dependent on what the issue is. Is it going to be you knew your bulls could defeat the fence that you had and were regularly escaping out onto the highway and the police told you to fix your fence and you didn't fix your fence, you're not going to receive in that situation that you weren't maintaining your fence according to generally accepted agricultural practices.
And along those lines, the other thing that I had on my mind as well was, making sure that we're not accidentally creating some sort of ability for a farm to just, dump chemicals or toxins or wastewater and just be totally immune if they're not following the practices, the best practices. So, I mean, is that kind of in line with the bull example? I mean, are there rules that you can talk about in that area regarding wastewater?
Sure. So by wastewater, it's basically manure. It's manure and what comes out of your it's a dairy farm is what your milk house waste. And that's usually managed as liquid waste. It's usually dumped into a lagoon or what we call the manure pond. And then it's generally land applied. And it has to be land applied according to a nutrient management plan. And that is a requirement of the state standards. It's also a requirement of certain federal standards. So if you are not applying that wastewater according to those rules, you're in violation. If you would not qualify for protection under the wastewater. Similarly with toxins, whether it's pesticides, you have to comply with the pesticides rule as part of the criteria here. Other material that is applied, fertilizer, lime, etc., that has to be applied according to your nutrient management plan as well. And there are other requirements. So there are standards for that type of activity. And if you just put trash on your property, well, that's not an agricultural activity. That's the disposal of solid waste without permitting that. That's not that's an ag activity.
Maybe anything further? Actually, anything further from you? Minnie, any additional discussion? We're going to be breaking here in a couple of minutes to S44, but any additional thoughts?
Is he gonna come back for section you were concerned about?
Right, mediation. Mediation section. That's on page 6. It's some clarity that I'm hoping to see if it's necessary to put in or possible. My concern being that there's something that is absolutely outrageously problematic that is causing a significant ongoing harm to a neighboring property. And the problem that required mediation could create by, because mediation is going to delay the process of going to court and, maybe getting a restraining order or anything like that. And so I'm trying to figure out, is this a long-winded way of saying, is there anything that we can do to clarify the details on when mediation has been attempted and when that requirement has been met by the plaintiff versus situations in which mediation may not necessarily be required and they can just go straight to court because it's something so egregious or anything we can do there?
So answering the question about how to determine whether mediation has been completed, that's on page 7. It's on 9 through 12. Person bringing the action based on nuisance or trespass has to provide the court with a sworn statement of an intent to resolve the issue or dispute for mediation. So there has to be an attempt. It has to be conducted according to the Uniform Mediation Act, which are standards that are within Vermont statute for how to conduct any mediation. But mediation is not binding. It's not like a binding arbitration where you go in and you're going to have to agree to the results. And if you don't agree to the result, then you and you still want to bring your claim, then you file that sworn statement. One of the purposes of this mediation is hopefully litigation is avoided. Maybe you don't come to a total agreement with your neighbor, but you come to some resolution how to address the activities of concern. As to the point of what to do if there is such egregious activity ongoing and that mediation would delay any remedy or redress of those egregious activities. I mean, I can look at language, how to do that. You could say that the court could order a temporary, if some standard was met, the court could order a temporary cessation of the aggravating activities until mediation is concluded. But I don't know what standard you would use, because not every claim is going to have an activity that's so egregious that there would have to be a pause in the activity. So I can figure out how to do that. I just don't know the standard you would use.
Well, speaking of pauses and activity, now that we have Senator Ruth here, I think we can pause 45 for a moment and go at 44 here.
And I will get back to the Senator Fihofsky with the number of states that have trespassed in the right to.
Thank you.
Coming back to 45 today, though.
I hope so. I don't know that 87 is necessarily going to take a full hour. Maybe we'll, I don't know, but if we don't get to it today, we will get to it tomorrow. Yeah, it's a fix. Yeah, it's like it's not just.
Oh, about how many?
It's the same.
If he only sends it to me, I'll send it to everyone.
There's lowercase and uppercase.
Back, we're still live and we are reversing back into S44. We have a new copy of it that makes some of the changes that we discussed half an hour ago.
Yes, so Rick Sable, Office of Legislative Counsel. So here. I have 20 minutes of them, so that's fine. Okay, so want to explain what I've done here. First of all, this is draft 1.2. And changes from 1.1 are highlighted in yellow. And what I've done, I'll explain why I did it, was I changed, we had state, local, county, or municipal entity. I changed it to public agency as defined in 1 VSA 317, or an officer, employee, agent, or independent contractor of a public agency. And the reason why I use public agency is because in this chapter where we are here, there's only 2 sections in this chapter. There's 4651, which we're not touching, and there's 4652, which is the one that we're making. So in 4651, we have this definition of public agency here. And they also cite 1 VSA 317, and they also say it also includes
Can you
officers.
show us 1 VSA 317?
I have that pulled up next. So yeah, this is the important part here, this A2. So it's any agency, board, department, commission, committee, branch, instrumentality, or authority of the state, or any agency, board, committee, department, branch, instrumentality, commission, or authority in public political subdivision.
Does that include sheriffs?
Yes, to me, this would include everybody in the state, any political subdivision. Right?
Okay.
Yeah.
I find that sheriffs often conceive of their authority entirely outside the structure of other state power. So that would be a willful misreading of somebody arguing that sheriffs were not covered by this.
Yeah, and again, this draft, I wanted to make sure that, you know, we have an officer, employee, agent, or independent contractor of a public agency. So, I mean, I think sheriff departments are,
Okay. I think so too. Yeah, I just want to ask the question.
So the only thing I want to double check, and I'm pretty sure I know the answer, I just still like to make assumptions. When you say a political subdivision of the state, that would include select boards, school boards, like all of those municipal or county, smaller.
and again, if you look at 1BSA 317, it's talking about public records. And, you know, that's going to cover every type of state agency that's subject to public records, public records acts. So,
Okay. Okay, so now because I'm gonna put my government operations hat on, there's a couple of political subdivisions we've actually exempted from public records, like the PUC. Not that I could imagine how the PUC would be involved in immigration, but I want to make sure that in those spaces where we've carved out exceptions, or we happen to carve out exceptions in the future, and in fact, the General Assembly is not subject to public records, doesn't still cover them.
so, you know, in this 1BSA 317, there could be exceptions that have been drawn in, but we're only bringing in the definition of public agency, not all the exceptions that we made.
Okay.
And we can go back to the previous definition of, you know, state, local, but I would defer to how we structure that phrase earlier in the same chapter.
I prefer sticking to what you've put in the new draft. That's my preference.
Okay.
You have another.
I would agree, knowing that none of the public records exceptions are brought in with it. I think this is actually a better, broader definition to capture what we want to capture.
So I made one more change I want to bring to the committee, and this is just me reading it several times and thinking how it could be interpreted. So the earlier version has, unless the governor authorizes. And I thought, well, wouldn't this allow a town to enter into an agreement before the governor has authorized it, as well, just as long as the governor eventually authorizes it. So if this is okay with the committee, I figured this is what you probably want, is that we want the governor to have already authorized the agreement before the town does something.
Yes.
Or the sheriff's deputies.
The way this is drafted maintains that it is the governor in consultation with the Attorney General's office, correct?
Yes.
Okay, I know we're only touching parts of it. I just want to make sure.
Great. Any, actually, Rick, anything further?
No, again, that other change was just, it's grammatical, but it's also, I think, important that, I think that's the intent that you want the governor who've already signed off on it, and not later after the, don't ask for forgiveness, what's the phrase?
I think the phrase you're looking for is ask forgiveness, not permission, but that's not what we want. We want, in fact, them to ask
But I thought
permission.
about that phrase and I was making changes.
Committee, any further discussion on this bill?
Yeah, I'm just wondering why we went from where we were to where we are now. With the original bill, now if we included, if Rick would roll it back down on there. The whole context was the agreement under AUSC 1401. Now we've taken it a step further, try to comply with certain individuals or agencies that want to have this in here. What is the purpose of that? The highlighted section is that simple. What's the purpose of this one?
That's what we talked about for half an hour. But so the purpose is to not create loopholes, because when you start picking or cherry picking certain things in law and staying silent on other areas, and that creates a question that we ambiguity as to, okay, the legislature created this rule for these specific entities, sheriffs, local police departments, but they didn't say anything about these other entities. So therefore, ECF or whatever hypothetical non-law enforcement agency could enter into these agreements, circumventing the process that's established in statute if a national emergency is declared.
My understanding, Rick, is this is we had previously had that list of county, municipal, and this is the language that just does that in accordance with how we already do it in statute.
And yes, and it's difficult to maintain uniformity across statutes that have been written for the last, 60, 70 years. And it really, that is important, but I think what's more important is you all get what you want. And to make it as clear as possible, because some statutes written 20 years ago are not clear. So I do want to defer that, but also make it clear that you want it written. So lay people and lawyers understand what your intent is. And this, I think, meets both because you are using the same term in the same chapter. So I think it marries those two pretty well.
One of the things I liked about this, and I've said this in this committee and on the floor and probably in a million places, is whenever the previous attempt at this was making a list.
Yeah.
And whenever we make a list, we inevitably leave people off the list, whereas this uses a definition that incorporates whomever that definition applies to. So it feels much more comprehensive to me that we're not making a list.
Any further questions or comments? Senator,
No, and just down below from this, we're just talking about these 1357Gs and 1401s opening up to all this no public agency. It's still just related to those two things.
Yes, it's this subject to.
Not sure if you would entertain a motion.
I'm gonna do my next then, unless there's anything further from the committee. And then I would ask.
So I would entertain, I would make the
I
motion
mean,
that we move S44 positive.
And this is draft 1.2.
so,
That's, I was just clarifying.
so Senator Mattis. Call the roll, please.
Yeah.
Good. Do you want
sure.
any discussion? Any discussion? That's your call, but is there any? Go ahead. Just throwing it out there. Yeah, Senator Norris.
No.
Senator Vihovsky.
Yes.
Senator Baru.
Yes.
Senator Mattos, yes. Senator Hashim.
Yes.
410.
Is there anybody who wishes to report this bill out?
I would do it.
What was that?
I would do it.
Great.
That way, the next big one, right on.
It'll be Bob, the next big one.
Big one's North Street.
Absolutely. 10 pages and above, they all look so forest.
We take a 5-minute break.
Oh, it's 5 minutes. Yes. Yeah.
Okay.